ranking member, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, there are few economic issues our committee will face that are more important than whether and how to reform our patent laws. Intellectual property, principally patents, are responsible for nearly 1/3 of all the jobs in the U.S. economy. Our patent system, while not perfect, is the envy of the world and perhaps the most significant driver of growth in our economy. I believe that issues of non-practicing entities, or the so-called patent trolls, present unique problems that are worthy of congressional attention. There's a disconnect when shell corporations with little or no assets can threaten thousands of small end users with ill-conceived patent litigation over ordinary business practices. If we don't know who these shell companies are, if the shell companies have no operating businesses or assets, and if they are given free license to engage in endless and costly discovery, we have a problem that requires our attention and legislation. But at the same time, we need to be careful in addressing these problems. Our first rule should be to make sure we do no harm to our patent system or take any actions which unintentionally discourage innovation or increase litigation. As the former director of Patent and Trademark Office, David Kapos, reminds us, we are not just tinkering with any system here. We're reworking the greatest innovation engine the world has ever known, almost instantly after it has been significantly overhauled. If there were ever a case where caution is called for, this is it. And in this regard, I don't see any reason why we should be considering amending the fee-shifting statute when the Supreme Court has just agreed to take up the very issue. Similarly, I see no rush to expand the use of business method patents when the PTO and the courts are just now beginning to review cases brought under the law we just passed. Any changes we make must be carefully balanced and consistent with our principles and constitutional imperatives. For 80 years, we've asked our federal judges, the experts on litigation, to develop rules for their own courtrooms. That system has worked well, and I see no reason to abrogate the principle of separation of powers now. And if we're going to consider crafting new rules on discovery, stays, and joinder, we should insist that the rules work the same for all parties, plaintiffs and defendants. Nor should we be crafting a series of special carve-outs from the legislation for the pharmaceutical industry. The last thing we need to do is to create two systems of patent law, one for the pharmaceuticals and one for everybody else. We cannot lose sight of the single most important problem to me that's facing our patent system today, the continuing diversion of patent fees. The most effective step we can take in responding to abusive patent litigation is making sure poor quality patents are not issued to begin with. To do that, we need to give our examiners the resources they need to review and analyze the hundreds of thousands of complex and interrelated patent applications they receive every year. And that's why yesterday, along with my colleagues, Representatives Watt and Issa and Collins, we've introduced bipartisan legislation, the Innovation Protection Act, which does exactly that on a permanent and statutory basis. This will apply regardless of the sequester or any future shutdowns. And I stand ready, able, and willing to work with members on both sides of the aisle in tackling these problems. But I would urge my friend, the chairman, to move cautiously, carefully, and deliberately. And I thank you for the opportunity to deliver my statement.